child and felt my prayers answered and felt that I had a direction that I wanted to go. And this is the year 2000, so what do? I pull up the internet, basically on dial-up, and I go to yislam.com with green text and, block letters on there. People were on the internet back then, they might remember, especially what Muslim websites were like back then. So I read on Why Islam, how do you take the Shahada? How do you become Muslim? And so, okay, you say the Shahada, La ilaha illallah, Muhammadan Rasulullah, and then you go take a shower. So I went and took a shower in my dorms, and alhamdulillah, I was Muslim, Of course, it's hard to be Muslim by yourself, and so I spent all my time that I could in the old town of Jerusalem, in the Arab and the Muslim quarters. And I met, there's really no masjids in Jerusalem except for Al-Aqsa. Al-Aqsa is like the only mosque in Al-Quds. There's Masala, there's prayer spaces, but there's not really any other mosques. I met a sheikh who was, running dawah efforts, going after tourists and whatnot in the old town, and he got me. And he said, no, you can't be Muslim by yourself. You can't take the Shahada on your own. You have to have witnesses. I was like, I think God saw me, but that's all good. I'll go and we'll do it with the witnesses. And so he went out and he pulled two guys off the street and brought them in, and he had me do it again. And so I took the Shahada again, La ilaha illallah, Muhammadan Rasulullah, a couple of witnesses there, alhamdulillah, I was Muslim. Which is great, but of course, to be Muslim, we're also supposed to pray. We're also supposed to pray together. And this was right after the Al-Aqsa Intifada had started. So there'd been 8 years of peace, and then I showed up for my school program, and then the second Intifada broke out. And the masjid was shut down to quote-unquote tourists, where they wouldn't let people who, because the Israelis had gone there and made all these problems, they didn't want white people going in there and making problems. When I went to go try to pray, if you're familiar with it at all, there's at the masjid there, at the Rama Sharif, there's kind of 2 levels of security. There's on the masjid grounds itself, there's Jordanian guards, the Jordanian army. And they said, brother, can you say the Fatiha? Okay, come on in. They had no problem. The Israeli guards, though, who were on the outside, they said, show us your ID. Show us where it says you're Muslim. I'm like, well, here's my California driver's license, but it doesn't say here's my passport, right? But it doesn't say my religion on there. They're like, no, show us your official paperwork that says that you're Muslim. I'm like, we don't do that, in America. They do that there. You do on your driver's license have what your religion is. That way the police, when they pull you over, know how much to discriminate you. Know how to treat you. Here in America, they know how to treat you based on the color of your skin. So we don't need to put religion on the driver's license, right? Like, we know how we do it here.
Accent also.
Yes. Lots of features that there are, yes. But, they wouldn't let me go in to pray. And so I said, okay, well, how do I get this official proof that I'm Muslim? They're like, oh, well, you get it from the Mufti. Okay, well, how do I go see the Mufti? Oh, his office is next to the masjid. Well, but I can't go to the masjid until I have the certificate that only he can provide, and his office is in the masjid. So it took a couple of months. And then the Dawah Sheikh that I knew, I stayed in touch with him and went to go visit and talk to him and learn from him regularly. And then one day when I went in there, he's like, all right, come with me. I'm like, okay, what's going on? And he takes me down, takes me up through the little streets, tunnels and everything like that, into somebody's rug shop. And then they pick one of the rugs up off the wall, and there's a tunnel that we go into. And we go into the tunnel, and we go down some stairs, and we go out some tunnels, and a bunch of turns, and some more stairs up and down, and eventually we come up in the office of the Grand Mufti. And so then I took my Shahada for the 3rd time, with the Grand Mufti as my witness. Alhamdulillah, I got a certificate that said that I was Muslim, and had my picture on it, and all those things. And then I was able to go pray at the masjid. Of course, when I went to go check in, the Israeli guards would hold my passport and all my papers for my protection while I went to go pray. So that you can imagine trying to come out of a crowd of 10, 20,000 people and then trying to find one specific guard who has your passport. That was always a hassle or always an adventure. But alhamdulillah, I was finally able to pray and able to go to the masjid. And it's one of those things that I will never forget as long as I live. That experience of feeling really as a member of the Ummah, and feeling that sense of power that comes from community. And I remember praying, and the way that the masjid looks, and the red carpets, and the columns, and everything, but even more than that feeling of coming out, of the crowds together, and leaving together. And it really meant a lot to me, and it meant, I felt deeply to myself like, I understood. I felt it in my spirit in terms of what we're supposed to be. Why are we Muslim? What are we doing, right? And so we come together, we pray, but we're coming together and we're praying for something. And at that moment, in Palestine, in the middle of the Intifada, right, whenever we come together, whenever we pray, we're centering ourselves on the oppressed, right? We were together there with all the Palestinians, praying with all the Israeli guards around us. Like, that's who we were. And that's always been a part of my deep belief, is who we as Muslims are. As we come together as community and we help and support one another, we also recognize the oppressed as part of our community. That those are the people that we must work and try to do the most for, those who are not getting the benefits that the society gives to others. And so that's always been a driving principle and a driving goal of mine. I changed when I became Muslim. I changed my career. I'd been planning to go into academics and become a professor in religious studies. Instead, inspired by the life of the Prophet, peace be upon him, and he was always active in society, trying to make things more fair, trying to uplift those who were downtrodden. I said, how can I do this the best? And I went to law school and followed that career. Most of my career, I've really tried to work with helping people complete their objectives, helping people find meaning and execute that in their lives. And that is both through a lot of work with nonprofit organizations, but also in this area of estate planning. A little bit more on my background real quickly. I have, as I mentioned, got a bachelor's in religious studies from UC Santa Barbara. I got my law degree from George Washington. I also have a master's from Bayan Islamic Graduate School. I've been working on Islamic estate planning for almost 20 years now. And then I've also acted as an expert witness on Islamic law a couple of times. This last summer I had the chance to teach a class at Bayan on nonprofit change management. I also have recently started a new firm with a partner who specializes in family law, so we can help people in that area as well too. But my main focus is on estate planning. What is estate planning? What is Islamic legal planning? What are the areas where we want to think about how we bring our traditions into this structure? And of course, the legal structure here in this country is very important. We're highly legalistic, and so how do we, it's difficult to fully live your life. It's impossible to fully live your life as a Muslim without confronting that legal system at some point and figuring out how you navigate it, how you integrate that in with your own personal beliefs. These are some of the legal documents or areas where, that might be of interest. We'll talk in much more detail about the estate planning, what all of those things mean, but it also comes up in terms of family planning, right? And, traditional to have an Islamic marriage contract that is translatable into U.S. law as a pre- or post-nuptial agreement. That's basically the same thing, Also, in the area of charitable planning, charity is a huge part of our Islamic tradition, right? One of the pillars, and then also something that's encouraged so much more beyond that. How do we do that effectively? This is important to understand the rules here, because if we don't do it the right way, it ends up costing us a lot more. This is something that's been recognized by a lot of community organizations, such as the NAACP, where they've made estate planning an emphasis because they recognize, and they work with the African American community, they've recognized that that's part of the disenfranchisement of the African American community, is that they don't understand, they don't have the access to the knowledge in terms of setting these things up. And so every time somebody from the community passes away, and if they don't have things set up right, that may cost the family an extra 10, an extra 20, an extra 40, an extra couple million in some cases, right, from not having the paperwork in place. When we look at that at the community level, that has a real big impact, right? Each family losing 10, 20,000. Now we've got 100 families in the community, 200 families in the community. How much less is going to the community institutions because people are paying more in taxes, paying more in court fees, because they're not trying to take advantage of the system, the way the system was built to be taken advantage of. Similarly, in setting up charitable endowments, donor advised funds, there's lots of different opportunities in terms of, if you want to give, how to structure that so that it's the most effective. And so that's definitely something that I'm happy to answer questions about, but I don't think we'll go into too much detail, overall. So the first question, or I think one of the first issues to look at is, what is a will? And a will is the most basic of estate planning documents. In estate planning, what we're meaning is what happens when you pass, what happens when you die. It's the inevitable, it's the one thing that's guaranteed to happen to all of us, And so how do we get ready for that and plan for that? Estate planning is that process. The will, like I said, the most basic document, you say how you want things to go, right? You say in terms of your body, in terms of your burial, what are the wishes there, who should be in charge of determining those things. And then also in terms of your income, in terms of your property rather, where is that going to go? How do you want it to be distributed? And so you specify those in your will. That's one of the legal document that you would do that. One of the most important things in all these documents is picking your trusted people. It's called something different in all the documents, and this one it's called an executor. But it's one thing to put all the things down on paper, somebody actually has to do them now. And so you have to find, and you have to determine who is the person that I trust, who knows my values, who has the strength of character to follow through on these issues, and you want to make sure that you identify the right people. Again, if we have all the perfect instructions in the world, but not the right person to follow those instructions, it's not going to happen. So that is definitely an important part. In terms of who should have a will, everybody should have a will. There's a strong hadith of the Prophet, peace be upon him, that Al-Sattar mentioned, during the announcements there, where the Prophet, peace be upon him, said anybody who has property, any man who has property, shouldn't let 3 nights go without creating their will. It's important to note that here, and we'll talk about it once we get to the Islamic section, the Prophet, peace be upon him, is actually talking about the voluntary 1/3, because they live in a Muslim state. They live in a Muslim society where the Islamic rules are going to be followed by default. We don't. So this instruction that the Prophet, peace be upon him, is giving to the community, again, is about 1/3, assuming that the other 2/3 is going to be handled according to the Quran. We can't make that assumption here. So I would say, to the extent that your Islamic tradition and following that is important, then it's even more important to do it here, because the default rules here are, of course, not Islamic. For not every family is a will really enough. You can die, with just a will, but if you have over a certain threshold of property, then your estate's going to be subject to probate. Probate is the court-supervised process of distributing the person's assets, trying to make sure that everything goes according to the instructions, or if no instructions were given, then according to the law, trying to make sure that everything is done fairly, and that sounds well and good. But the problem is that courts are really bad at their jobs. Courts take forever. It's not a good decision-making process that you have to go through. It's very expensive. It takes a long time, and it's also a public process. And so all the things that are going on between the family are now part of a public record. Really, it's the advice for anybody that has over the threshold of property, which is about $200,000 right now, a little bit more than $200,000 in California. That if you have over that amount of property, then your estate is likely to be subject to probate, have to go through the court. If that's the case, then it's advised that you create a living trust. Creating a living trust will allow you to avoid that court process by assigning a person that you trust, somebody called the trustee. And again, somebody that you know, that knows your values, that you know has the strength of character to follow through on them, and you can have them follow your instructions and them execute on the things instead of a judge with multiple lawyers involved. This, of course, will save the family lots of money, lots of effort. When you've just lost somebody that's close to you, important to you, you've got a lot of things to be handling, a lot of things to be dealing with. The last thing you want to be doing is having to go to court and deal with that system and talk to lawyers. For every family that's potentially in this situation, creating a living trust will leave the family better off. The main type of trust that we're going to be talking about is a revocable trust, also called a living trust. It's called revocable because you can revoke it, you can cancel it, you can change it, you can terminate it, you can put stuff in, you can take stuff out. During life, the property is yours. It's not under restrictions. So that's good, because you're still able to use it as you need during your life. However, one of the things to realize is that because the property is still yours, because you still have direct control over it, the IRS and courts are going to treat it that way too. So a living trust, like we would use to avoid probate, is not one that would give you tax or asset protection benefits. There are things to do in that regard. If there are tax issues, For most people now, at this point in time, the estate tax, this tax that they put on the amount of property that people own when they die, it's very high. It's like $15 million at the federal level. It used to be under $1 million. So it used to be 15, 20 years ago, a lot more people had to get involved in complex tax planning. That's not the case now. Now with the threshold being that high, unless you have property over that level, then you don't have to worry about the estate tax. That doesn't have to really drive the process. Another good point, or another important function of the living trust, why we'd recommend it to families, is kind of simplifying the administration at that point. So there can be, when somebody passes, 3, 4, 5 different legal processes ongoing. We could have a trust to resolve, we could have bank accounts, there could be real estate, some different real estate in question. Each of these issues might have a different process that it has to go through. Creating the trust helps consolidate all that. And we put all of the stuff kind of into the trust. And then we have one process to follow, one thing to do, instead of having to potentially go through 4 or 5 processes, again, saving families lots of time, lots of money. In terms of the probate process and how long that can take and what it can cost a family, my worst case, my worst horror story is I got paid last year in 2025 for a case that I stopped working on in 2012. So it was a very bad case involving 2 different wives, very bad idea for anybody who's thinking about that. But it was a messy case, and I worked on it for a couple of years, but then for whatever reason it wasn't for me, it was for another lawyer to come on and try to finish it out, and it took him 13 years and he wasn't a bad lawyer, he was a fine, good lawyer, I trust him, but the process took that long to work out all of the issues. That family probably lost upwards of $1 million by taking their case to probate. They had a family business that, because of the disputes, because of the fight, nothing could be done with. And so the family business just kind of sat there and lost value while the fight was ongoing, and they weren't really able to get anything out of it. And so, this is an extreme case, but in a normal case, it might be, $10,000, $20,000 of attorney's fees, and still 6 months, 2 years, something in that range to get through the probate process. So if somebody's looking at that, thinking they might be on the bubble, generally recommend to go and get it done. That'll be better for the family in the long run. A step beyond the revocable trust is an irrevocable trust. And so this is one that can't be edited or changed. It can't be canceled. And so when you're setting it up, you got to be really sure this is what you want to do. Once you give that property away, you create the trust, and then we fund the trust. We put property under the legal ownership of the trust. With a revocable trust, again, you change your mind, you can take it back. I don't like so-and-so anymore, okay, we can give it to, we don't like A, we can give it to B. If you put stuff under an irrevocable trust, you're largely giving up your powers to do that. With an irrevocable trust, you have to normally either give up the control of the assets or the benefit of the assets. So you could set up, for example, a kind of charitable trust where I'm still going to manage the account, but it's going to ultimately go to charity, and I can't use this money for myself right now, or I can't use all of this money for myself. So that's an example of the kind of limitations that are there for an irrevocable trust. Normally used for a special purpose, and can also give asset protection benefits, though more often I work in the area of business structuring in that regard. I think these are very specific to each person's situation, and also very specific to the assets that we're considering. What's the property that's kind of causing the concern that we need to address? And then you have to kind of come up with identify the right kind of trust to deal with that property and deal with those issues. There's thousands of kinds of irrevocable trusts potentially, and so it's definitely not a one-size-fits-all kind of thing. All right, so now we get to the fun part of the Islamic part, the Sharia law in the USA. So I would say the first point to get is that, and we can talk about the political situation, and not just now, but going back, the political situation, but overall, which is not good, the political situation to say. But overall, the idea that there's this huge conflict between American law, between Western traditions of law and Islamic law, that these are incompatible, as some people in Oklahoma or something else might say, that's really just not true. There's, well-founded connections between Islamic law and American law and Western law. The way that we normally try to approach it with the way I try to approach it with incorporating the Islamic legal tradition into the system here and how we do that for a client is we kind of look at the four corners of the document, is what we say. We look at the frame that you can see there, and that has to be American. We have to meet all the American rules. We have to have all the right witnesses and have the right things notarized and the right waiting periods and time frames that the American law requires. But within that frame, you have the freedom to put what you want. With some limitations on public policy, but in the normal course of this work, in the normal course of executing Islamic tradition, in this area that doesn't come up. It comes up more in the area of family law rather than estate planning. Any limitations that might be there. The U.S. historically, traditionally has some of the strongest religious protections of any country in the world. That isn't to say that Muslims have not been subject to discrimination and that there haven't been, unfounded crackdowns and bad actions targeting the community, but just overall our basic freedom to have beautiful centers like this and come together and practice our religion that is well founded in the Constitution and the First Amendment, as in any global legal document. One of the leading cases on this issue is actually specifically about estate planning. The case there I mentioned, Iwad v. Zarax, which comes out of Oklahoma. Oklahoma was one of the states that maybe, they're talking about it again now, but maybe like 2012, 2011 timeframe, there was many states that went through and passed these anti-Sharia bills where they said Sharia law shall not be enforced in American courts, which it isn't. It just never has been. That's not the way that it works. So, but the first challenge to those laws was about somebody who had Islamic inheritance in their estate plan, and will the court enforce this? And in the very first hearing, the federal judge said, yeah, no, this law is getting thrown out. People have religious freedom to have their estate plan according to what their religious traditions are, and that was upheld on appeal and has been the law very clearly ever since then. So things could be coming down the line, that target the community and target community institutions and nonprofit organizations, I think in specific much more. But as it comes to these individual rights and individual property rights, this government's not coming after property rights. And so I think in terms of creating wills and trusts that, those issues aren't necessarily there. There's many similarities, like I mentioned quickly, like the freedom to contract, the freedom to put things down. That's part of the Western legal tradition, but also part of the Islamic legal tradition, that we are free with certain limitations, right? We're free to conduct ourselves how we believe is fit, as long as it's according to the basic parameters. Within a marriage, there's some certain basic parameters that are there, for example, but most everything is available to be negotiated between the husband and the wife. If they want to handle property a specific way, if they want to divide childcare a specific way, they have the freedom to decide and determine those things as suits them best. Similarly, within the Islamic tradition, there's a portion that you're encouraged to give to charity, called the mawarith. That's yours to choose. That isn't one of the things that's mandated. So there's a lot of freedom to contract, freedom, a lot of liberty and options under both systems. Some scholars have even theorized, I don't know, exactly how strong of an argument that it is, but that what we have in America we call common law, and it comes from the British system, and its judges have a lot of power. Judges have a lot more power in the common law system than they do in the civil law system, which is practiced in mainland Europe, in continental Europe. They use the civic system or civil system. Some scholars have said that England adopted the common law system after contact with Muslims, and that the common law system where the judges have the power resembles traditional Islamic courts, and that they might have used what they learned from the Muslims as being the basis for the common law system in the UK. Again, I don't know how strong of history it is, but it's something that some people have said, and at least indicates that these things are not, these radically incompatible, ideas or frameworks like some people present them to be. So what are the Islamic rules, and how does it work with regards to inheritance? Well, the first section, and I misspoke a second ago, is the wasiyah, that is your voluntary section. The wasiyah is what normally is translated as will. If you read the word will in the Quran, The Arabic word, in the English translation of the Quran, if you read the word will, the Arabic word is going to be wasiya. And the wasiya is the voluntary bequest. So it's up to 1/3 that Muslims can give freely and are encouraged to give to charity. Generally, it can also go to family members, but under most of the Sunni schools, not family members that would inherit from you under the Mawarith, which is the structured inheritance to family. So if somebody has specified what the charity or other issues that they want to support, at their end, then we're going to give that section to the charity that they've specified, up to 1/3 of the total amount of the estate, and then the rest of it goes to their family according to the structures laid out in the Quran, and then also supplemented by Islamic scholars throughout its history, throughout the tradition. There's a couple different ways to break it down, but I think the simplest way to look at it is there's some relatives who get a set share, and that's primarily going to be parents and spouses. Parents and spouses, it says they get 1/6, 1/4, 1/8, one of those numbers, and they get that percentage. And then we take what's left over, and that's what we call the remainder. And generally that's going to go to the children. If you don't have children, then it's likely that might go to your siblings. That would normally be the people that would come up after the children. But if there's children, they generally are going to be the ones who inherit that full share of the remainder. An issue that comes up, and this is one of the things, there's some differences between the Sunni schools, the Jafari school, and the four Orthodox Sunni schools. There are some differences there. One of those differences is that the Sunni schools, the Shia school says that a daughter is able to inherit a full share, while the Sunni schools say you have to also find a male relative, that a daughter can only inherit up to half, and that there should be a male relative who takes all of that. This is an issue that comes up sometimes in foreign countries, and leads to people formally switching allegiance, switching sides, if they want to change the way that their inheritance is going to go. And then, again, it goes to more distant relatives that can't be fully given to children. So some other things that come up and that people would want to be, consider as part of their estate plan. I think one of the most important is what's in California called the Advanced Healthcare Directive. In other states, it might be called a living will. And this is the document where you specify, if I'm still alive but not able to make my own decisions, if I have some issue of incapacity, who should make those decisions for me and what's the guidance that I give to them. And a few years ago, this was something that I didn't, I'd leave it up to people and say, right, if you feel that you have medical issues that need addressing, then that's great, we can get into it. Nowadays, having dealt with family issues myself, it's something I definitely recommend to everybody, where medical technology is amazing and people are living longer and longer, and it's just a reality that as that happens, we lose capacity. And if we wait too long and the person has already lost capacity and is having dementia or some other potential issue that limits their ability to make decisions for themselves, then they can't make the decision to give somebody power of attorney. So if you wait until the health issue arises, then it's too late. You kind of have to do it ahead of time. And again, I've just dealt with my grandparents and my parents kind of dealing with memory loss and other issues as time goes on, and then seen it when you don't have these things in place. And then you need to go to a court to try to appoint a custodian or a guardian or something like that. All of my job is trying to keep people out of court. All of my job is trying to keep people handling the stuff internally, because that is such a disruptive and expensive process for anybody to go through. Then one of the main issues that people have, specific health issues, those definitely can be addressed in a power of attorney if there's some things that need, instructions related to a condition or something like that. But most of the question that people are going to ask relates, do we pull the plug? That's kind of one of the main questions. That and organ donation are kind of the main questions that are addressed in the healthcare directive. The question, again, I'm using the kind of popular phrase, pull the plug. The more formal way to put it is if somebody's still living, but the doctors have agreed that they're not likely to recover to any real life with any real standard of living, and their life is being maintained artificially, be that through a respirator, be that through artificial feeding, be that through some other method, right? Do we continue to keep that person alive, even though the doctors have said, there's really no chance. And if the doctors believe that there's a chance, then they have to do something. They can't stop doing something unless they have a specific instruction not to. But they generally have to keep doing something until they believe that it's done. If the doctors advise you that it's done, what do you do? Do you keep going, or praying for a miracle, extending life artificially? Sometimes it's happened that they've been wrong and people have recovered. Or there's another way of looking at it of, if the doctors have said there's really no chance and they're right most of the time, how much of a burden do I want to put on everybody? Is this really the benefit for the person who's being kept alive artificially? If their standard of life is that difficult, is that the right thing for us to be doing? Those are difficult questions. Those are difficult questions to answer, and they're ones too that you get to choose amongst. So all of the Islamic scholarship, the modern Islamic scholarship that I've seen on this point is pretty universal, where the decision to discontinue life and to pull the plug is not euthanasia. It's not an action furthering death. Of course, that is suicide, euthanasia, things like that are amongst the strictest, taboos, the strongest things that we cannot do within Islam. But again, all the scholars who have reviewed this are universal in that this is not euthanasia. That the discontinuing of life support, if it's keeping somebody alive artificially, is not the same as taking an act to further their death. Again, you don't have to pick one or the other. Islam doesn't say this is the right one, but you get the choice in terms of what you feel is best for your family. So another issue that comes up, and that's very commonly talked about, because most of the time we're working, you can't do these for individuals, but most of the time we're doing trusts for a married couple, for a family. That's normally the way that it works together, in part because California is a community property state. So what that means is that when a person passes away, what community property means is that any property earned during a marriage is owned 50-50 by both spouses. So property from before marriage isn't considered community property unless the person puts in a joint account to something else to make it be community property. So if you own a house before you get married, that house does not become community property just because you got married. If you own a paid off house, if you make payments to the mortgage during your marriage and you're working to make the money to pay the mortgage, part of those mortgage payments are going to be considered community property. Then at that point it can become very, very complicated. You have community property unless you elect separate property. You have to go through a whole different postnuptial, prenuptial, marital property settlement agreement, something called along those lines, in order to change the default community property to being separate property. Now, one thing that I have, does get brought up and does get asked is, what's more Islamic, community property or separate property? What's the Islamic way of doing things? And then a lot of people say that separate property is the Islamic way and that community property is something different. My thoughts, my response is, one, during a marriage, parties have the option to choose how they want to treat property. Islam doesn't say you must do it this way. It does have a certain set of rules that are set there by default, but if a husband and a wife decide we want to share this property, we want to share the labor in this way, they have the choice to choose what's best for them. So if a couple knows that California laws community property, and they get married in California, well, they've chosen community property, I think. Another thing to remember too, though, to think about as well is, so separate property, everything that each spouse owns, they own separately, right? And that nobody has the claim on the other one. And under the Islamic tradition, that exists for women, but not for men. So under the Islamic tradition, women have separate property. A property of a woman is her property, and nobody else has a claim to it. She can voluntarily give it to them if she chooses, but her husband or her father or nobody else can come and say, hey, you owe me this money, I need this money for this thing, you need to give it to me. You can't do that to her. It's her property. That isn't the case for men in the Islamic tradition. Men in the Islamic tradition, I would say, primarily hold property in trust for their families. That in an ideal Islamic court, in an ideal Islamic society, if a man wasn't taking care of his wife, wasn't taking care of his mother, if his father's not there, wasn't taking care of his sister, if he's the closest one, that he could be taken to court and be sued for support. Not just the bare necessities, but keeping her at the standard of living, in the method that she was accustomed to. And that is his legal obligation to give his property to her. And again, the woman doesn't have that same obligation going back. So I don't think either community property or separate property, which are the options that we have here in California, really capture what is exactly the Islamic tradition. What's the right way to go with all of these issues? Again, I think it's a family decision, an individual decision, and something I'm happy to help people talk through and work through, but not one that I can necessarily, kind of provide with. This does lead to an issue that affects many families here, in that if things are owned in community property, or just rather the way that the Islamic inheritance works, which is sometimes different than the way that many people here structure their property, is that when the first spouse passes away under the Islamic tradition, their property is distributed. Their spouse gets a share, but the majority of that property will go to other people, not the spouse. In America, in the Islamic tradition, if we go back again, we just went through what are the obligations of a male, of a male child potentially in a situation if they get the inheritance, but their parent needs the money. There's a mechanism there. That mechanism doesn't exist here in America. There isn't a way to kind of force the kids to take care of their parents. And so how do families deal with that? How do they make sure that there's enough funds available to take care of the surviving spouse and provide for them and any care that might be needed? Those are difficult questions and things to kind of consider and work through. Another one that comes up in this question is the unequal distribution between sons and daughters, also husbands and wives. Mother and father both get the same share. So it isn't true that in every circumstance a man gets twice the share of a woman under Islamic inheritance, but it is true in some circumstances, particularly sons and daughters. I just talked through the difference in property rights, right? So in a perfect Islamic world, your son gets 2 shares, your daughter gets 1 share. Your daughter's not spending that 1 share on herself. She doesn't need to spend that 1 share to take care of herself. She's being taken care of by your son. So he doesn't need the 2 shares that he has, because her money's hers. It's just for her. That's for her freedom, right? It's not for her sustenance or her basic needs. She's got her brother to take care of that. Why he's getting twice the share? Because he's obligated to take care of other people. That legal system, those types of legal protections don't exist here in this system. So those are questions and issues again that families raise with me, and that we work to talk through and try to find what's the right answer for them. As it comes to these issues, the Islamic tradition and how each family, each client of mine might put that into place, that's not for me to say. I have a master's degree in Islamic studies. I do not have any janazas. I do not have any traditional lineage. I don't have any authority in any Islamic school. I have the ability to look up in books. If you know, I know a lot of the stuff from reading it already, but if we want to learn, all right, what were the Shafi'is doing in 1600? We can go look that up. We can go figure out historically what different Muslim groups said and did, and I can let you know that. I can let you know this is what the majority of scholars, here today say, right? If that's what matters to you. If you care about what the scholars said 100 years ago, we can look at that, But I can't make that decision of what's right or wrong for each individual or each family. The person to talk to about those kinds of issues is your sheikh, is the imam, is the sheikh, somebody else that that knows you, that is a part of a traditional lineage that you follow, that you believe in. And so those things, I think people are the right ones to, if you have a question, is this the right or wrong thing for me to do? Is this permitted for me? Those are the questions to bring to a trusted, real Islamic leader. Again, I have some Islamic knowledge, I have some understanding, but again, from an academic perspective, not from a perspective of this is sinful or not sinful, for example, to be able to tell you that much. So I think with that, we can get to some Q&A. And so, happy to entertain any questions that people have.
Assalamu alaikum. Jazakallah khair for the presentation and your history, how you became Muslim. Quick question. First one is, if it's above that probate limit, can the inheritors gather together and say, hey, we're going to do it we all pledge that we're going to do it evenly, whatever. Can they do that?
No. So then, yeah, the court will still have to
Put their nose.
the court will still have to put their noses in it. Yeah.
And to avoid, if I understood you correctly, and I've been to these seminars before, so I'm just trying to clarify myself. In order to avoid the probate, if you had a will and a trust in place, then the court will simply execute what you have legally filed.
So if you have a living trust in place, the living trust, so it gets a little confusing because there's certain property that's subject to probate and certain property that's not. You give all your property that's subject to probate to the trust. So your house, that's normally one of the biggest assets, right? We're going to give that to the trust. On paper, it's going to belong to the trust. Again, during life, because it's a living trust, everybody knows it's still really mine. I can buy it, I can sell it, I can put it in, I can put it out. But when I die, the court is going to respect the legal fiction, they call it, that the house wasn't mine, that the house belonged to the trust. And so then the family, whoever you assign to be the trustee, they can execute on the stuff. They've got the authority, they can take the trust to the bank, they can go to the real estate agents, they can go do this stuff themselves with the authority of the trust. They don't have to go to the court. If one of the beneficiaries disagrees and says, this isn't going fair, you're not giving me my share, or you're not supposed to be in charge, I'm supposed to be in charge, they can go to court. You haven't lost the right to go to court. People can still go to court to guarantee that it comes out fair, but you don't have to do that by default. You can assign the person that you assign, and that's the trust that lets you do that.
Typically, I'm presuming that everything works on templates, and you probably have templates for these things. People cut and fill if I see your consultation and your law understanding. Typically, how long does it take to prepare something like this? And also within the frame, I like that frame idea you had. We will bring in the Islamic inheritance into that. So let's say that I get it all done within the frame, it's all good and go. But let's say that somebody wants to challenge that division of how the male gets two and the female gets. Let's say I have two daughters, they challenge it in court. Is it challengeable in court?
There's not been any, I've not seen any successful challenges of the distribution. And I haven't seen any cases in terms of Islamic distribution that have actually gotten that far. I have seen cases from the Jewish community that have gotten that far and that it hasn't been overruled as a matter of public policy. I think that there's not been any cases where Islamic inheritance has been struck down.
Typically, last question, how long does it take to get this done? If I took you as my lawyer?
It might take us normally a couple weeks to kind of put the documents together. We can rush stuff if somebody's got a trip coming up or going into the hospital or something like that. So that does happen, and we can try to do that. Normally the longest part of the process is making the decisions. And so, our brains don't like to think about this. It is the inevitable, but our brains naturally go a different direction. And so what I find is that as we talk through the issues, a lot of times new issues come up. And people may want to go talk to family about that. And maybe when they go back and talk about that, they come back and they talk to me about the decision and a new issue comes up as a result of that. And now we have to go back and talk to family again. I want to work to create something that's going to be good for as far as we can see. Right? Once we've opened up the process, I don't want to rush through it. I want to be as complete as possible and try to make something that's going to, inshallah, last for the rest of the life. And if there's major life changes, a living trust, we can come in and we can change it. We can make those adjustments, but if we can foresee the problem right now, let's try to work through it. Again, that getting the understanding and then making the decisions, that's only the longest part of the process, but I think the most important, right? It's easy, anybody can go online and you can in 5 minutes download a valid California will or trust. Is it going to be a will or trust that does what you want it to do? Is it going to be something that fulfills your wishes and your visions? I think that's a much more difficult thing to say and to know. And so working through, helping my clients, making sure that I feel they understand the decisions that are being made, making sure that they are aware of what's going on, that's a big part of the process and probably the most time-consuming part.
So if you amend, let's say you add or subtract a property from the trust, is that considered an amendment?
So no. So the property is separate from, the trust is separate from the property that's within it. And you can buy and sell property in and out of a trust without needing to amend the trust.
Okay. And then, last question, does the trust have to file a tax return each year?
So a living trust does not. So a living trust, because again, during life, the money is yours, you can put stuff in, you can take stuff out. You can go get a separate tax ID for it if you want to. Talk to your accountant about that first. I generally wouldn't advise it. But normally, no. For a living trust, you don't need to go through all of that. Yeah. There were some questions over here, too.
Assalamu alaikum.
Wa alaikum salam.
Jazakallah khair. Such an informative. I have three-part question.
Okay.
The first one is simple. How much does it cost for an average cost for the trust? And the second one is, does creation of the trust triggers from the tax standpoint property reevaluation, whether it's a house
Good question.
or even for the commercial property?
Yeah.
And my third question is, does it consider from the taxation standpoint a step up by creating a trust?
Yeah, no, good questions. On the cost aspect, it depends, depending on how much property the family has, and then, also how broad, how many issues they want to address. For a living trust package, including a living trust, wills for both the husband and wife, and then also deeds, the amount varies between $3,500 to $5,000, also depending on if they want either power of attorney, the healthcare directive, and again, how many properties they are. But for most families who own real estate, it's going to be $35,000 to $5,000. In terms of the tax issues, the living trust is invisible. So that's one of the great things about the living trust. When you transfer something into the living trust, we don't have any Prop 13 reassessments. The property taxes stay the same. We do have to pay the deed filing fees, but we don't have to pay fees more than that. That applies to residential real estate and commercial real estate. It's not a taxable transaction. It's kind of it's not a real transaction, is what the real estate offices say, because the owners are the same before and after. So because it's the same people on the deed, we're ultimately in control before and after, there really hasn't been any exchange, and so there's nothing to report. Yeah.
So this might go back to getting a recap on the irrevocable trusts, what scenarios we could use them in, but I'm also wondering how it relates to Islamic scenarios, where maybe a person might choose to use a wealth or an endowment as part of their inheritance, or I don't know, how does it help protect, pass down certain assets from along the generations, or the scenario that you mentioned where a husband passes away before his wife and he wants to preserve her right to stay in the home. So I've heard maybe sometimes people put the home in a wealth in that sense, and how does that relate to the legal structure of irrevocable trust or the living trust?
Yeah, and a waqf is directly comparable to an irrevocable trust. Those are, and it's been the concept in the Islamic tradition and the practice in the Islamic tradition, since the time of Islam, since the very beginning. I would not do it on a personal level. You're going to get in a lot of tax problems if you try to do that with a primary house. They're really so complicated and specific that it's kind of difficult to talk about it, at large. There absolutely could be certain circumstances. I would advise that most people who are interested in thinking about that, especially if it's for charitable purposes, most people, it's called a donor-advised fund, which is a kind of a financial account that can be set up, is normally going to be way more efficient for you than setting up an irrevocable trust, and it'll give you more tax advantages and stuff like that. So for people who are thinking about that, I'd advise trying to look at a donor-advised fund. In terms of the internal family situation, I wouldn't advise it then, just because it gets stuff really complicated. And again, tax issues come up. You get lots of benefits from being the personal owner of the house that you live in. There's just lots of benefits that come from that. And putting it under an irrevocable trust, you're going to lose all of those benefits that you get from personal home ownership.
Is there an Islamic mechanism, for example, to allow in a scenario like is there an Islamic mechanism to allow, for example, the scenario where husband passes away and would like wife to stay for the remainder of her life in the homes, so that the home does not get distributed and then she's.
Yeah. I mean, so we put clauses in there that are, to not distribute the primary residences unless it's absolutely necessary, that the trustee should take any and all steps to make sure that that's the case. If we want to follow the most traditional of the Islamic rules, then there's a kind of a conflict that comes up there between, do the kids get their inheritance or does it stay to the spouse? From a traditional Islamic perspective, the kids can't give up their inheritance until it's real. So they can't give up their inheritance until their parent is dead. So they can't make that decision ahead of time. But they could at that point say, you know what, I don't need the money, but I see that mom does. And you know what, when mom dies, it's going to come to me anyways. So really, why am I worrying about this, right? But what I've been advised from traditional scholars is that decision can't be made until the question is real, that they can't do it ahead of time.
Just let me stop and share for the Islamic centers, but can you expand on the concept of the one-third hadith that you talked about? We know many masajids and organizations struggle for donations and stuff, but imagine if all the people, Muslims, contributing one-third of their inheritance to these organizations, where would we be? So if you can expand that.
Yeah, that's absolutely something. That's what we call planned giving, and it's really an effective way for people to support community institutions and organizations. We're encouraged to give up to 1/3, and if we do it through inheritance or do it through different kinds of charitable trusts, it comes up a lot if we have appreciated assets. So if we have a business or some stock or some real estate that maybe we bought at $100,000, but now it's worth $1 million. Well, when we sell it, we're going to have to pay a lot of taxes. We can get a lot of benefits avoiding those taxes by donating it. We can get the full write-off of the full $1 million, plus avoid paying the taxes on the $900,000 of gain. So there can be a lot of advantages from giving it through that kind of planned giving structure, donations. It also helps the institutions a lot because they can plan and they don't have to be putting so much of the efforts into fundraising, and so that makes the programs go better too, for people who are there. So there's lots of good reasons to do it. It is very much part of the Islamic tradition, and to have an endowment or a waqf that's set up. And normally, so for an endowment would normally be, which is many times is similar to a waqf, but would kind of function as what we would call here an endowment, where we give a gift, but the organization doesn't take most of the principal. So maybe I give somebody $1 million and they invest it. They use the investment income to support the project. They can only, on the U.S. legal system, you can only spend it down 5% per year. Maybe they have policies they don't spend it down at all. But the principle is maintained. And once they've got enough principal, enough assets that are there, then the investment income can be something meaningful and can produce many, many times that, over its lifetime. And there's lots of examples of that, of small gifts initially turning into millions and millions of dollars because they're put in an endowment and then can renew, decade after decade.
Yeah. So this irrevocable trust kicks in when both husband and wife pass away, right?
I'm sorry, what was?
Both husband and wife pass away.
Okay.
Then it kicks in, right? The trust?
No. So it's called a living trust because it lives with you and then it dies with you too. So the living trust you set up and you're in control of it during your life. And then once you pass away, normally your spouse is going to be, you and your spouse are in control of it together, and then one of you passes away, and then the last one's in control of it. When that person passes away, you picked the person you want to be the alternate trustee. It's their job to get the stuff out of the trust, to give it to your beneficiaries and close down the trust. So it doesn't turn into an irrevocable trust. You can set up an irrevocable trust and then fund that through a living trust, but that's a whole different thing, not what happens automatically.
Thank you.
Yeah, sure.
Again, if you can answer that step-up basis, I think.
There's no tax issues. That's not considered a step up.
In a partnership, if you have multiple partners, and if only one partner wants to do the revocable trust, and does the shares of the partner goes into the revocable trust, and how does that, when you record, would that not create a reappraisal of the property in that case?
I mean, I think we, you know, if there's one specific case, I would need to see the documents and talk to you about that. But in general, it wouldn't, if you were to put you would put the shares, your ownership rights under the partnership, or maybe shares in an LLC, shares in a corporation, we'd put those under the trust. That isn't a taxable transaction. That isn't, because again, the owner at the beginning was you, and you're still the owner. So we have to, if there's real estate, we have to file the deed with the county, but we tell the county when we're filing that, the owners are the same before and the owners are the same after. And so there isn't any reassessment, and there isn't any charges that relate as a transfer. Sometimes they'll come back and they'll audit. LA County is the most with this of all the local counties. If you transfer your house, they might ask for a copy of your trust to make sure that you're not, you know, giving it to somebody else through the trust. Or if you transfer to an LLC, they might contact you. If you've got commercial real estate, including residential properties that you own and that lease out. If you have your primary residence, it's recommended that you have that under the living trust, because that will make sure that you preserve your interest deductions as well as the reset of bases that happens when somebody inherits real property. So there's some tax advantages that come from owning real estate personally. Putting it under the living trust helps preserve those. If you own other real estate, then the general advice is you put that under an LLC, and then put that LLC under the trust. And that gives you the protections that if something goes wrong with that property, then they're going to sue the LLC. They're not going to sue you and have access to your other property as well.
And the step-up basis is up to 15 million?
I'm not sure about whether if there's a limitation on that there. The 15 million is roughly what the estate tax threshold is now. But I'm not familiar with the limit on the step-up basis of real property. I'm gonna have to research that. So what we're talking about here is about capital gains, which is like when you sell something and you made money off of it. If you bought your house at $100,000 and now it's worth $1 million, you had $900,000 of gain, you're gonna have to pay $900,000 worth of taxes on that. If somebody gets real estate specifically through inheritance, not as a gift, not as a lifetime gift, so writing your kids on the deed does not give them this benefit. That's an important thing. Sometimes people try to do something, good by giving the house directly to the kids. They're going to be missing out on some big tax benefits if you try to do that. When they get the property directly through inheritance, if the property was then worth $1 million, the new tax basis will be $1 million. So if after inheriting the property, they go and they sell it, the IRS treats it as if they paid $1 million for it, and there's no taxes on it for them when they sell it. So there's some big benefits, again, that come from getting real estate via inheritance versus a lifetime gift.
I don't think there's a step-up cap. It's when you pass away. I just had a planning idea. I wasn't going to ask the question, but maybe not. But one thing I did see one time was a family qualified personal residence trust put in place for a kind of scenario that she was talking about, where you gifted it to the kids, and then you had to produce the cash also when the husband died, and she's able to actually rent it, get money out of her estate for staying in the house for her lifetime. So it was just an idea that I had. I was going to bring it up, but she wasn't. So.
She's in the back.
Okay.
Hey.
Assalamualaikum. I have two separate questions. One of them is it a good idea to have, for a name of the living trust, to have your name, real name associated with it or on it? I know that usually it is attached to the social security number of that person. Or is it better to just give it some fictitious name? Could be mayonnaise or whatever. And is that perfectly okay?
It's perfectly okay to pick a name that's not associated. I think by default we'll use one that is the family name because this makes stuff more clear. And then most of the time, we're trying to show them that it is the same, right? Because we're transferring, we had all these questions about the taxes, so we're trying to show that it is the same before and after. Sometimes people might want more privacy and they might feel better. One of the things to be aware of, though, is that your personal names are still listed on any deed as the trustee. So if I've got a property that belongs to Mary and Jim, but then we're putting it in their trust, we're going to deed it to Mary and Jim as trustees of the Mary and Jim Trust. So even if you call it something totally different, if they Flying Eagle Trust, it would be Mary and Jim as trustees of the Flying Eagle Trust. So that's difficult to do with a personal residence, but that is also one of the reasons why for other properties in LLC might be a good idea, as you do get more privacy then.
The other question is, what is the role of the will as related or unrelated to the living trust?
Yeah. No.
I've been told that the living trust really is not worth as much if it is not tied or if it does not have a will that actually says what do you do with those things that are listed in the trust.
So, I mean, I don't know that the value of the will, it's important, but I wouldn't put it that way per se, where the trust will still do its job, even if you don't have a will, but the will handles other things that the trust doesn't address. So the trust is only about financial issues, but we have more than that going on in our lives. We aren't only money, right? So as it comes to picking the person who's going to be in charge of the last rites and who's going to determine burial issues and things like that, that's can only be done in the will, can't be done in the trust.
And can the trust reference the will?
It can, but normally we do it the other way, which I'll explain in just a sec. There's also normally some property that we don't put under the trust. For example, cars. Every real estate company knows how to deal with living trusts. That's a normal part of their thing. The California DMV doesn't know how to deal with trusts. If you put a car under a trust, it's a huge pain if you ever try to sell that car again. We don't do it. We put cars under LLCs, then put the LLC under the trust, but only for cars that are worth more than $205,000 or whatever the thing was. So for most people, you will still own your cars, but our hope is that the value of those cars is under that $205,000, so it's not going to have to be subject to probate. What we do is we put in the will, it's what they call pour-over wills, where we say any and other assets that weren't in the trust, we're giving them to the trust now. We're putting everything under the trust. And again, that helps simplify administration. So the will and the trust work together. And if people have the trust, they also are going to need wills in place, or certain issues won't be addressed. If people don't have real estate, if people are under the property threshold, then they may not need a living will or living trust. Then that may be just not necessary for them in their financial situation, and for them they'd only need a will. But anybody who has a trust, you also want the will.
Thank you.
Sure.
Let's limit the questions to 2, please, at a time.
Anybody else?
Yeah, go ahead.
The brother had it in the back.
Assalamu alaikum.
Walaikum salam.
The will versus the living trust. The will, does it need to be recorded?
So neither the
County and also, I'm sorry,
yeah.
the will, how long will it take? Would it have probate also, or it doesn't have probate?
So the will and the trust are not recorded anywhere generally. A trust or a will, I guess, could potentially be recorded with the California Attorney General, but I've never advised my clients to do that. You're just making your own business public. There's not really a reason to do that. Some people, there might be a reason to do that, but 99.99%
Just
of situations, no.
notarize it?
The will is witnessed, the deed is notarized, or the will is witnessed, the trust is notarized, the deeds are filed. So anything where there's an official record of property, and we want to give the property to the trust, we have to go and we have to update that record. And so one of the biggest things is real estate, so we have to create new deeds. Those are filed with the county. Those become part of the public record in order to effectuate the real estate transfer.
Okay, how about the time in the probate? I mean, does it, the will, take
So
a long time?
If you have over a certain amount of property, then your estate will be probated. If you have a will or don't have a will, the will doesn't prevent probate. The will, if you have over that threshold, then you'll still have to go to probate. But the will give your instructions. If you don't have the will in place, we say that somebody passed away or somebody died intestate, and that means we just look at what the law of California says. And California has a thing in there that says if you're married and you have one kid, then your spouse gets this and your kid gets this. If you're married and you have 2 kids, then this goes to things. If you're not married and you have parents, so we just look to the California law and follow that.
I have a question for you. Have a property, have everything, have one daughter, she have mental problem. If I happen to the mother pass away, what should we do with the law here? And who gonna take care of the girl have mental problem?
That's a thing that you've got to talk through with your family, not a thing that I could really tell you. Once you
Your family
decide,
have nobody, you have no one.
again, that's not a thing I can, once the family has kind of figured out what they want, then I can help them put that into place. But I can't make a determination about who the best person to care for somebody's daughter is. That's a decision for them, not one that I can make. I might try to seek some social assistance and kind of see what organizations are out there that might provide that support. Yeah.
Oh, yeah, I think that's what I think about, because she think probably the poor can want someone in maybe order to take care of the girl and she can help the authority for doing things, but I don't think gonna do that way.
Yeah, I mean, if she has property, so a thing I do sometimes is what's called a special needs trust. And so if there's a child.
She have no family, nobody, she's only a daughter and she have a little bit problems.
Yeah, I mean, she's got to identify who that trusted person is going to be. I think that's something she's got to first work on, that practical issue of who would be the people that she'd want to take care of her daughter. But that's unfortunately not something that I can, provide insight on.
Want someone can be living trust, yes.
Yeah,
To take care of
to
her.
potentially be her trustee or.
If we can see the court and see the lawyer, see everything, paperwork, they go through with us, yes. Thank you very much.
Sure.
Maybe these are the last two questions, probably.
Alhamdulillah, all said and done, we have an irrevocable or a living trust, XYZ, you got the will going, everything going. You have one property, one real estate property, all paid off, alhamdulillah. Now, the issue comes of liquidity. You deviate out, you have 5 children, XYZ, 2 boys, 3 girls, whatever you have, you divvied out, but the ones living in the house don't want to sell it, or they put a protest. It's not the right time to sell. The liquidity becomes a problem. Do you either force the liquidity, or how do you handle that? How do you divvy it out? And the second question was that the trustee that you assign, can they put a curveball, the trustee or the
Well, this is exactly who decides as the trustee. So in the situation that you described, in the question, do we sell the house? Right, okay, we've got one house going to 5 kids. How's that gonna work? Do we sell the house and divide the 5 shares? Do we put the house under an LLC and then lease it out, and then each of the kids gets a fifth of the income each month? Or do all 5 kids move into the house and live together? It's up to the trustee to determine which one of those circumstances is the best. And that's why it's, I think, the most important, really, like, we'll talk through all the decisions and make through, try to figure out all the financial questions and whatnot, but the person that you assign is ultimately going to be the one. And, we had COVID, we've had a lot of crazy experiences, right, that we did not foresee. There's no way that anybody predicted what's happened in the world the last 5-6 years, And so having that, we can go through, we can try to predict everything, we can try to say, if X, then this, if Y, then this, but we're going to get a curveball. And so to have that trusted person be the one who's standing in your shoes, somebody that you've talked through difficult issues with, who has insight into, how you feel about your family. If an issue, if a conflict was to come up between your kids, who would be a good one to try to resolve that? I think those are the questions about, who you pick to be the trustee. Talk through that with them first, so that they know what's coming up. But yeah, I think that's when you've got to pick the right person, because you don't know exactly what the circumstance is going to be in the future. I think we had one more question, but I'm happy to answer more after.
Assalamu alaikum. In your toolkit, I wondered if you could talk about how you use some of those tools, like life insurance, maybe for that gentleman that had a business key man insurance, so that people can meet their estate planning goals.
Yeah, no, so it's, what I can say on that aspect is it's really important to have a team in addressing these issues, right? Like, I'm not an accountant. I know a little bit about the tax stuff. We can talk about the step-up basis. We can talk about the avoiding Prop 13 reassessment. I can't talk to you about income tax, and that's the number one thing that affects people right now because state tax is gone. So you need a good accountant, right, who's going to advise you and tell you about those things. And we also need a good financial planner, who's going to be able to address those issues. What I can say is you should diversify. That's my level of knowledge on these things. You don't want all your eggs in one basket. I can tell you all the little pithy, cliche things, but in terms of what exactly is the right financial tool, talking to an expert who works on that is definitely the right thing. Life insurance is a big one in a lot of cases. It probably comes up the most for me in privately held businesses. So if you've got a small business that you own and you're, let's say, 50-50 with another partner and somebody passes away, what do? You know, like does one partner just keep running the business and then still sending 50% of the money to the other person's family, but now they're running the business on their own, right? Do they, if the business is worth $1 million, do they give $500,000 to the family? Where's that $500,000 coming from? Most businesses don't have 50% of their value sitting around in the bank account to just give a check out. So those are one of the circumstances where life insurance, if both of the partners, we might do what's called a buy-sell agreement. And then as part of that, both of the partners will get life insurance. And then when one of them dies, the life insurance policy actually pays to the company. And then the company uses that money to pay the family of the partner who died, so that they can get their buyout at that time. So, yeah. Put together the team to work on the specific situation.
Islamic. A couple of questions. First one is I just want to make sure that you don't have to record or document the trust that you will make with the county or any other.
So real estate records have to be filed. The deed has to be filed with the county in order for there to be an effective transfer there. But the trust and the will do not have to be publicly filed. Those can be kept confidential to the family, and then if a situation comes up, that's what you use. So if, we've got an issue with the trust bank account, you can take the trust in to the bank and show them the trust. You don't need a court order. The trust is good enough.
The second question is what triggers the amendment in the trust? At what point do you want to make changes in the trust, or what mechanism you have there?
So whenever your mind changes is when you would make edits to the trust. So sometimes there might be changes in the tax law, so if new issues come up there, then there might be some recommended changes. If you have a trust, probably a good idea to have it reviewed every 5 to 10 years to see if there are any new changes in the tax laws. But changes in property do not require edits to the trust. If you change the people that you want to be, if you change the people that you either want to be in charge, who you want to be the trustees, who you want to execute on your wishes, or you change the people or the organizations you want to give the stuff to. Both of those would definitely require an amendment to the trust.
You said last question, but we'll make second last question. Yes, last question with you.
Thank you very much, Todd. Very enlightening. So sort of piggybacking off the stars point on how we can generate, donations for the various Islamic centers, educational centers over here. Endowments is one way. As some of us are reaching into retirement age, there are RMDs kicking in. There's going to be a huge tax penalty that's going to come up. Not penalty, but I guess we'll be. So I guess there is something called as QCDs that come into play, qualified charitable donations, I believe. So how can that be used to actually donate to the various Islamic centers,
So normally when somebody's setting up an account like that, they are donating the money to a like technically if you're with Fidelity, you're with Schwab, or you're with this or that, you're technically at that point when you're setting up one of those accounts, donating your money to that nonprofit, to the Fidelity Fund or Fidelity something or other. But you're still largely in charge of the accounts, and through the account you can assign who you want it to go to. There's generally a maximum amount that can be given out each year, right? So there might be, depending on the type of account, a 5% or 15% kind of maximum that you can give out of the account each year to whatever nonprofits that you pick. But you can kind of pick those through those, pick charities through the platform that's there.
You might be talking about, there's a new rule about being able to give, I think it's $100,000 out of your retirement plan without having to pay tax on it. That might be what you're talking about.
Yeah,
and it's kind of new.
I've heard about that.
Yeah, and those are the reasons why we want to get an accountant involved. Because for all the specific income tax and other deductions that are there, I know about some of them, but I don't know about all of them, and I always want to make sure whenever these questions come up that you just have to, right? The new tax code is 5,000 pages every year. And so if somebody's not focused on that 100% of the time, we're not gonna catch all the
Yeah,
issues.
the big beautiful bill also.
Oh, boy.
Assalamu alaikum, thank you, this has been very enlightening. I have a revocable trust, how do you amend it? How do I update it? It's quite old.
Yeah, I mean, we could take a look at it and see what the changes that you want to make are, but you the same as you did it before, you do it again. And that the new one is the good one.
But I had my financial advisor's friend do it,
Mhm.
and so he passed away, and so
Mhm.
did his business, so it kind of failed away with him. I still have the
Mhm.
paperwork.
But the-
I just let it sit there, and then I eventually bought my townhouse, and my kids are now 20 and 21. So I'm currently widowed, and so I had quite an extensive amount of who's gonna take care of my kids, who's not gonna take care of my kids, and whatnot. So all that has been changed, because now my kids are adults, but I also bought a townhouse. How would I update that and include the townhouse?
So if there's a change in property, you don't need to change the trust, you need to make sure your deed says the trust. So what I would say is maybe contact me, we can take a look at your trust and talk it through with you and see if you really need to change it. If what you did is still good, but the issue is just we need to assign the property, then maybe what you need to do is do a deed that puts the townhouse under your trust.
Okay, so yes, I'll be contacting you to help me do that.
Sure.
Thank you, I appreciate it.
Sure, my pleasure.
This will be the last question I'll ask on behalf of brother. They're here, but their assets or everything else is overseas. What's the best way of dealing with that?
Talk to a lawyer over there. Yeah. So, from a practical, that is the legal advice is I can't give you legal advice outside of jurisdictions in which I am licensed, which are California and New York. If your issue is outside of one of those two places, I can't give you legal advice. From a practical perspective, most Western countries will respect. Like I know, for example, we can put UK property under a US trust. I've done that with clients where they have a trust set up in the US, but they also own property in the UK. We don't have to set up a new trust in the UK. We can put their property there under their US trust. At the same side, I've had a bunch of clients in Pakistan and Egypt and Jordan and other Muslim countries. They don't care what you say in America. They don't care one iota what you said in your American will or trust. They're just not even going to look at it. They're going to go according to their own rules.
It's been enlightening. Jazakumullah khair for everybody for attending. As Todd mentioned, actually all the information is right there, pathfinderattorneys.com. Attorneys plural, so Pathfinder. And this is also being recorded, inshallah, and we'll try to put it on YouTube so you can reference it later on. Jazakumullah khair for coming. Assalamu alaikum wa rahmatullahi wa barakatuh.